Okay, we're now live. Sorry for the wait.
Good day, everyone. Welcome to the grand final for the second annual edition of the Taylor's Intervarsity Mooting competition. On behalf of the organizers, I would like to thank everyone for joining us today. My name is Nagadurga Vijayakumar, and I'll be the bailiff for this session. With me today is Isadora Reyes and Keanu as the assistant bailiff, and Sarah Tham as the timekeeper. We will commence proceedings once the judges are ready. Judges, are we ready to begin? Thank you. This court is now in session. The panel of judges consists of young Arif, Tuan Darryl, Goon, Siew, Chye as the presiding judge, young Arif, Tuan Ong Chi Kwan, and Miss Raja Elaine Soraya. The appellant is represented by Lo Rui Thong and Po Ka Man. The respondent is represented by Tan Ka Loong Keanu and Joey Tan Juan Xing. Counsels for the appellant and the respondent are each allocated 45 minutes to present their respective cases, which is inclusive of a maximum of 5 minutes each for their rebuttals and surrebuttals, respectively. We will now invite the first oralists to begin their submissions.
May it please you, my lords and my lady. Before I begin, my lords and my lady, am I audible? My name is Lo Rui Thong, and with my co-counsel, Ms. Po Ka Man, we appear for the appellant, Satoshi Sendam Bahat, and my learned friend opposite, Joey Tan Jung Sing and Tan Ka Loong Keanu, appear for the respondent, Python Sendam Bahat. I'll be submitting on the first and second ground of appeal, which is the issues of legal advice privilege and consent judgment, and my co-counsel, Ms. Po, will submit on the remaining grounds, which is the issues of frustrations and exemplary damages. My lords and my lady, before we start, would you like a brief summary of the facts of the case?
Sorry to interrupt. Judge, you are muted.
Justice Darryl, you're muted.
Yes, very briefly, because we have read the documents in advance.
Satoshi Sendam Bahat and Python Sendam Bahat entered into a sales and purchase agreement of 2 million antiquities, whereby Satoshi had paid 1 million. Due to COVID-19, Satoshi suffered massive financial loss, and the managing director of Satoshi was informed that the antiquities only worth 1 million. After a series of arguments, Python commenced an action at High Court to recover the balance. On the case management day, consent judgment was recorded and provide that Satoshi was to collect the goods from Python's premises. However, 2 days later, Python refused to deliver the goods, and a new solicitor filed a fresh action to set aside the consent judgment and to recover the balance. In response, Satoshi sought discovery of correspondence and counterclaim on threat of conversion to sought for exemplary damages and argued that the agreement had been frustrated due to COVID-19. Dissatisfied with the High Court decisions, Satoshi, the appellant, appealed to the Court of Appeal, thus disappeal. With my lords and lady permission, I'll start submitting my first ground of appeal. Turning to the first ground of appeal, which is the issue regarding legal advice privilege. The appellant submits that the appropriate task for legal advice privilege in Malaysia should be the dominant purpose task, and consequently, the correspondent is not privileged. For the convenience of the court, legal advice privilege is a privilege which protects communications between clients and solicitor for the purpose of giving or obtaining legal advice. The issue that arises here is what is the task for the word purpose? My lords and my lady, the jurisprudence concerning legal advice privilege has matured and evolved since the case of Bellbell and Air Indian, which is a 1988 case, and in this case, it was laid down a broad purpose task. The current approach should be gleaned from the recent English Court of Appeal case, which is the case of Regina on the applications of Jet2.com and Civil Aviation Authority, Law Society of England and Wales intervening, a 2020 case. In this case, it was held by Lord Justice Higginbotham that a party seeking to sought legal advice privilege must demonstrate that the dominant purpose of the communications or the document was to obtain or give legal advice. The appellant would like to give 3 reasons to support that the appropriate task for legal advice privilege in Malaysia should be the dominant purpose task. Firstly, the dominant purpose task strikes an appropriate balance between 2 competing public policy, which is the full and frank communications between solicitors and clients on one hand, and on the other hand, the disclosure of all available evidence to the fullest extent in court. Information secured by discovery frequently means the difference between success and failure of the case. Absolute protections to communications between solicitors and client should not be allowed. The dominant purpose test provides an appropriate safeguard against an overly broad application of legal advice privilege. It can avoid situations where court need to arrive decision while being deprived of access to relevant communications, which only has minor purpose of seeking legal advice. Secondly, the relationship between client and solicitor has become more and more complex nowadays. Business has become more wide-ranging, and the nature of advice given by solicitor, either external solicitors or in-house solicitors, they may also extend to other fields of learning, such as financial policies, business arrangement. Therefore, the legal and non-legal context might be so intermingled that determining the dominant purpose of the communication is necessary. Lastly, Australia, Singapore, and Hong Kong, they have incorporated a dominant purpose test in the legal advice privilege, and they actually demonstrate that such a test works in practice. And in fact, they do strike an appropriate balance between 2 competing public policy, as mentioned earlier. Therefore, it is appropriate for Malaysian law to go in line with other significant common law jurisdictions because it provides certainty for business operating globally, since communications will be treated in a similar fashion. This is important to consider for international clients and lawyers but especially when they are multinational companies and have subsidiaries in numerous common law countries. After establishing that the appropriate task should be the dominant purpose task, the appellant would like to submit that the correspondence are not privileged because they did not come into existence for the dominant purpose of obtaining legal advice.
Counsel, before you go into that, how do you read Section 126 of our Evidence Act? And how does that play into your argument that the dominant purpose test is the applicable test in our country?
To answer your lordship questions, the legal advice privilege has been codified under Section 126 of the Evidence Act 1950. However, in this section, they did not clarify whether communications must be for the dominant purpose or the broad purpose of obtaining legal advice. Therefore, we should actually refer to English cases in order to determine the scope of the said provision as well as the current state of law. Since the law has been developed since 1988, and now there are a new case in 2020.
Can I also ask, you submitted on the importance of certainty, remember? You said that it was important for commerce to know or to be certain as to when a particular correspondence is protected or not protected. But surely if that is the case, shouldn't we be leaning towards protecting? We're having a more blanket protection so that it is certain. Because otherwise, companies, when corresponding with solicitors, will be wondering whether there's a dominant purpose or not dominant purpose, and that seems quite difficult sometimes to ascertain in the course of doing things. So on the argument of certainty, shouldn't we then be leaning towards protecting correspondence between lawyers and clients on more sort of, blanket or, be more leaning towards protecting rather than not protecting? Could you respond to that, please? Thank you.
To answer your lady questions, yes, it is protecting them because privilege, the very purpose of legal advice privilege is to encourage clients and solicitors them to disclose information. However, even though they have such a privilege, it does not mean that they can protect every communications, because if every communication is going to be protected, then what would be disclosed in the court? Then that will not bring fairness in the court because there's lack of evidence. Did I answer your ladyship questions?
I will mull over that answer. Thank you, Counsel.
Much obliged, my lady. With your lordship and ladyship permission, I'll now submit on my further ground.
Right.
So after establishing that the appropriate task should be the dominant purpose task, the appellant submits that the correspondents are not privileged because they did not come into existence for the dominant purpose of obtaining legal advice. In the English Court of Appeal case, the case of Conlon and Conlon, which is a 1952 case, Lord Justice Maurice held that privilege does not extend to a communication from a client to his solicitor, authorizing him to offer terms of settlement. It was held that an inquiry whether plaintiff did or did not authorize his solicitor to write those letters is not an inquiry about the confidential communications between clients and solicitors. The authorities support that a mere inquiry about authorizations of solicitor does not fall within the ambit of legal advice privilege, and it ought to be disclosed. Applying this case to our case, the appellant submits that privilege should not also be extended to correspondence from a client to his solicitor, which merely involve authorization to record a consent judgment, because such a correspondence is not for the dominant purpose of giving or obtaining legal advice. It is merely an approval. Further, my lord and my ladies, the correspondence here, they aren't just privilege-free, but they're also material and relevant. On the fact of our case, it is the best evidence which could show that the consent judgment is recorded with consent of the parties. Therefore, as a matter of fairness, it should be disclosed, and there should not be a right to withhold evidence simply because the correspondent has a minor purpose of obtaining legal advice.
How do you know that this particular correspondence does not contain any requests or legal advice?
To answer your lordship questions, according to the facts, there was a few weeks of negotiations and the party actually were close to reach a settlement. And according to the facts, the High Court judge actually gave them a day to actually reach a settlement, but they choose to enter into the settlement in 1 hour. In that sense, actually meaning that they should be protected.
So does it mean that the fact that the time given for them to reach a settlement is short, it must necessarily follow that the correspondences would not contain legal advice?
Yes, because there's only 1 hour and they already have.
So in 1 hour, if it is 5 minutes, you can't. If it is 10 hours, then it will contain legal advice. Is that your argument, counsel?
But if they truly does not have the intentions to.
We don't know, isn't it?
Yes, we do know, but we can infer from the facts that there is they just enter into a consent judgment in 1 hour. So that, and the legal and non-legal context is so intermingled. So it is difficult.
All right.
May I inquire if there's uncertainty or you're not sure if that correspondence may contain some advice, because we can't know for certain surely for now whether someone could possibly still within that hour quickly type something in. So which way do you think the court should lean then if there's uncertainty?
So the correspondence actually there's a few letters, meaning there's a correspondence. However, in our case, we are seeking for the correspondence that actually disclose authorization parts. So we don't really want to know what the respondent did or did not actually provide legal advice. We only want to know whether they did or did not authorize. So the legal advice part is not for us to actually discover. So we just want to know about the authorization part.
Authority you're relying on allow the court to blanco or to cut out certain passages from a correspondence?
In the case of Conlon and Conlon here, so the letter is that my client authorized me to say that you will accept such an amount of settlement. But in our case, it is a settlement that whether you accept to settle the matter in such a way. So it is applicable in our case.
Carry on.
With my lords and my lady permission, I'll now submit on my second ground of appeal. Turning to the second ground of appeal, the appellant submits that the consent judgment could not be set aside for one of consent or one of authority. The appellant would like to raise 4 points. Firstly, according to paragraph 11 of the mooting questions, start from the 5th sentence. Here, the respondent asserted that the consent judgment was entered into by their previous solicitor, Chye & Co. without their consent. However, there are a few important points that can be inferred from the facts. According to paragraph 9 of the second sentence, the fact clearly provides that there are a few weeks of negotiations and settlement talks, and the parties were close to reach a settlement. This clearly shows that all the parties had authorized their solicitors to negotiate and conclude a settlement. The negotiation was a clear indication that the respondent actually wanted to withdraw its claim against the appellant. Further, on the day where the consent judgment was recorded, the solicitor actually stepped out to contact their clients after the learned High Court judge advised that if a settlement could be finalized on the same day, then a consent judgment could be recorded. This is again a clear indication that Chye & Co. did seek for respondent's consent, and the fact that the consent judgment was subsequently entered into after an hour must be a result of such a communications. It is.
But counsel, from the facts, it is not clear whether within that 1 hour, the lawyer had successfully contacted the client to get your client's instructions. That's the first point. And secondly, can you address the court in the event that the fact is that counsel could not contact the clients, whether it makes a difference?
To answer your lordship questions, it will actually lead to my second point, which is solicitor actually have implied authority to set aside, solicitor actually have implied authority to enter into a consent judgment. According to the English Court of Appeal case, the case of Watt and H.P. Clifford and Son, Lord Justice Brickman held that solicitor retained in action has an implied authority between himself and his client to compromise the suit without reference to the client, as long as the compromise does not involve matter collateral to the action. So the issue here is that we need to consider is on the fact the consent judgment, does the consent judgment involve matters which collateral to the actions? So in that case, the solicitor has authority to compromise because the subject matter of the dispute is the defective house. So a compromise which involved handing back the house in return of the current value of the house was a compromise which went to the heart of bargain. So with that in mind, and returning to our case, the consent judgment does not involve matter which collateral to the actions because the solicitor here decided that the issue should be settled by delivering your goods, which is the very goods in the actions. This was a compromise which does not involve extraneous subject matter. Therefore, it is within the most usual and limited notions of authority of the solicitors. So the authority had established clearly that there is no obligation to prove express authority because solicitors actually have implied authority to compromise. So if the respondent here, they genuinely have agreed against their former solicitor, they actually should resolve it by making a claim against their former solicitors. It cannot form a premise to set aside a consent judgment and truly cannot be an excuse to escape a bad bargain. Lastly.
And what if there is a correspondence between the client and the solicitors where the client had expressly told the solicitors not to settle? And in that situation, should that sort of correspondence be discoverable?
However, on the fact of our case, the respondent now they are asserting legal advice privilege and they does not want to disclose, meaning that they have no evidence to support their argument that they actually has such a consent or not consent.
So you may settle or not settle, it is not advice. You mentioned that earlier, isn't it?
Yes, but according to the authority that I've cited, because they have implied authority in the end of the day, the solicitor can actually decide it.
All right.
And lastly, my lords and my lady, setting aside of a consent judgment actually will open up an unscrupulous litigants and to repudiate a properly recorded consent judgment. There are a lot of compromises are made in court without the presence of the client, and this is almost inevitable where cooperation is involved, like in our case where Python and Satoshi are involved. Further, On the fact, the event actually took place on the date of case management. It is also quite common for clients to be absent from court during case management. Therefore, it is highly undesirable that the court should place any unnecessary impediments in these convenient procedures. As such, in the instant case, the respondent's assertion concerning the lack of consent and authority must fail, since the solicitor has implied authority. Therefore, the consent judgment remains valid, binding, and enforceable. That concludes the argument that I wish to submit on behalf of the appellant. Perhaps there are some issues on which I may be of further assistance.
Questions? No. All right, carry on. Second speaker.
Much obliged, my lord and my lady.
May it please the court. My name is Charmiane, the co-counsel of the appellant. I will be submitting on the issue of frustration and exemplary damages. Before I begin, I'd like to first apologize for my background, as I am unable to keep it completely plain without potentially being interrupted during my submission. With your lordship's and your ladyship's permission, I will begin.
Yes.
Turning to the third ground of appeal, the appellant wishes to first submit that the learned High Court judge has erred in finding that the contract was not frustrated by COVID-19. Here, the appellant will present three main points in support of this submission. That is, first, the supervening event in this case has occurred after the agreement was executed. Second, the supervening event in the present case was also not foreseeable. And thirdly, this honorable court should adopt a more liberal approach towards frustration and allow for impracticability as a ground for frustration. For the convenience of the court, it should be reminded that under Section 75, Sub 2 of the Contracts Act 1950, a contract to do an act which after the contract is made becomes unlawful or by reason of some event which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. Accordingly, for a claim of frustration to succeed, the supervening event must first occur after the contract is executed. Second, render performance impossible or illegal. Third, it must be unforeseeable and when the contract is executed. And fourthly, it must be unpreventable. My lords and my lady, the first point of the argument the appellant wishes to submit is that the supervening event in the present case has occurred after the contract is executed. To support this claim, it is material to clarify that the appellant is not claiming that COVID-19 pandemic itself as the supervening event per se, but rather specifically the various restraints imposed by the government in response to the outbreak. This is because per the facts of the case, as can be seen in paragraph 6 of the facts sheet, it is the standard operating procedures imposed by the government that has inhibited operation of Satoshi's restaurants. With that said, the supervening event can then be clearly observed to have taken place after the contract was concluded. This is because, per paragraph 5 of the fact sheet, the contract was concluded on the 2nd of February 2020, and the standard operating procedures imposed by the government under the MCO came into force on the 18th of March 2020. Now, turning to the second point of argument, my lords and my lady, the appellant wishes to further submit that the supervening event in the present case was not foreseeable. Although there have been various outbreaks in the recent years, which may lead many to conclude that a viral outbreak is not entirely unforeseeable, the extensive regulations imposed by the government in response to the COVID-19 pandemic is nevertheless unforeseeable. To support this claim, the appellant would like to shed light onto the impact of the few recent pandemics as compared to the COVID-19. With SARS, the pandemic persisted for approximately 9 months from discovery till the end of the pandemic, and the accumulated global death toll was at 774. With H1N1, the pandemic persisted for approximately 20 months from discovery to the end of the pandemic, and there was an accumulated global deaths of over 284,000. With COVID-19, however, the pandemic has persisted for only approximately 15 months to date. However, the accumulated global deaths are at 2.64 million as of the 14th of March, 2021. As such, the pandemic is evidently way worse than its predecessors. Therefore, despite the occurrence of SARS and H1N1, no one could have anticipated the severity of COVID-19 and the far-reaching restrictions put in place to combat the outbreak. Lastly, the appellant would like to humbly submit for the court to adopt a liberal approach towards frustration. Again, for the convenience of the court, it should be reminded that under Section 57 sub 2 of the Contracts Act 1950, for a claim of frustration to succeed, the alleged supervening event must render performance impossible or illegal. Historically speaking, a contract can also be frustrated if the supervening event has radically altered the contractual obligation so as to make it unjust to enforce the original contract. Under these guidelines, the Malaysian law on frustration has historically rejected impracticability as a basis of frustration. The word impracticability here is a legal terminology that describes instances where, although a contract is technically still physically performable, it has nevertheless become so excessively burdensome in an economic sense that it could not have been anticipated or been contemplated by the parties when they were contracting. With that said, the appellant wishes to clarify that it had contracted to purchase the respondent's antiquities at 2 million ringgit and has paid the 50% of the purchase price before MCO was implemented. This leaves a 50% balance that is to be paid by Satoshi despite the implementation of MCO, which paralyzed the operation of his various restaurants to a large extent, and in turn, Satoshi sustained massive financial loss, as can be seen in paragraph 6 of the fact sheet. As such, the contract has been rendered materially impracticable since it is no longer within Satoshi's financial capabilities to perform the obligation of paying the 1 million ringgit balance without sustaining excessive economic hardship that was not within the contemplation of either party when the contract was executed.
I'm so sorry, Councillor, may I just interject? The issue of not having the money to pay is something that the court see all the time. Surely that cannot be the reason that this contract is going to be frustrated.
Yes, my lady. Actually, moving forward, I will be addressing that very point. So if you will allow me, I will proceed.
Sorry, would you mind just answering the question very quickly? Thank you.
Yeah, of course. So in fact, within this submission, the respondent intended to acknowledge that Malaysian courts has historically adopted a firm position on economic downturn being insufficient to ground a claim of frustration. And this was provided in the case of Tai Kim Yew and Sentul Raya Sendian Berhad. And here, the court stressed that frustration only applies where there is a radical change in circumstances that renders performance impossible, and thereby they actually rejected the claimant's, the defendant's claim of economic hardship as a ground for frustration. However, as the appellant will soon submit, Malaysia's law rigidity in regards to this aspect of frustration may actually yield highly inequitable outcomes under the context of today's society.
The inequitability or the unjust position surely butts both ways. On the other side, we've got the recipient also waiting for the money, presumably also facing financial hardship. So I'm wondering how far we can take this argument, Council, that we should be looking at financial difficulties as a reason to frustrate a contract and to say that it's now practically impossible to perform.
Yes, my lady, to address your concern, the respondent your concern is duly noted by the respondent. However, it is within our contemplation that the court, in construing the doctrine of frustration more liberally, should not be adopting a wide approach. In that sense, it means that although the courts may recognize impracticability as a ground for frustration, that does not exclude the court from ascertaining the surrounding circumstances to ensure that the allowance of impracticability as a ground for frustration is made with just and equitable reasons.
So, Ms. Poh, according to your argument, if I enter in a contract and I find that I've lost some money in my business, I don't have to honor it because it's frustrated.
To address your concern, my lord, respectfully, that is not what the respondent intend to convey, but instead, it is merely because the doctrine of frustration is, in fact, perhaps centuries old, and a doctrine that has persisted for so long, that has persisted to be rigid for so long, should maybe be considered to be loosened since the society has developed, and in light of the current pandemic outbreak, a lot has changed in terms of the way people live their lives as well as the business operations. Therefore, in order for the law to properly govern the people that it seeks, in order for the law to properly regulate the people that it seeks to govern, it has to be rigid, but as well as be flexible when it needs to be.
Therefore, when I can't pay, it's frustrated.
Sorry?
When I can't pay, it's frustrated.
Again, respectfully, that is not what the the appellant intends to convey. As I have previously mentioned, even if the court was to adopt a more liberal approach, the court should also remain vigilant in considering the surrounding circumstances so as to not allow parties to simply claim for frustration under the grounds of economic hardship to escape a bad bargain. However, in situations where performance is materially unjust or impractical, really extremely impractical, then perhaps the court may adopt a more liberal approach.
Counsel, if I understand your argument correctly, and it's a creative argument, you are basically saying this, if I'm not wrong, that not in all circumstances where a party cannot make payment, it will be frustrated. But you are saying that in this particular case, because it is so extreme, it is so extreme, therefore the court should make an exception that under this situation, frustration can apply. That is your argument, isn't it?
My lord, if I may actually bring up one of the points that I intended to submit subsequently, is that okay?
Yes. All right.
All right. Referring to Tritle's book, Frustration and Force Majeure, Tritle actually argues that in reality, there is little that is truly impossible, and that in most instances where performance was found to be impossible, performance had merely been impracticable, extremely impracticable. And to support this statement, he actually cited the example of Taylor and Caldwell, and he highlighted that the contract that was frustrated in this case could have actually nevertheless been performed despite the fire that actually destroyed the music hall if the defendants had only expended a considerable sum to rebuild the hall and subsequently rent it out. Therefore, in light of Tritle's argument, it can be seen that although the courts have been very rigorous in terms of ensuring that contracts must be impossible to perform in order for them to be frustrated. In reality, if we were to look a layer forward, if we were to really unpack the situation, there are many instances where impossibility is merely just extreme impracticability.
So if, for example, there is an earthquake and it affects the party's ability to do business, of course, and you would consider that as a situation of frustration?
In that case, I believe that would be a suitable case for frustration because an earthquake is an unforeseen event, something that cannot be controlled, and it is something that has materially rendered performance impossible or radically different if the earthquake had destroyed the business premise or so and so.
Assuming it didn't destroy the premises, but it just affected the business, perhaps the chain of supply has been cut off for some reason. Yeah, does that qualify?
To answer your lordship's question, I believe that that may, in correct circumstances, qualify for frustration because the supply chain is fundamental to the operation. If the supply chain is fundamental to the operation of his business, then naturally the earthquake would have made it either extremely impractical for him to set up the supply chain all over again in a short period of time, or it would have rendered it impossible.
But where do you draw the line, assuming the company fails to make money because perhaps the petrol price has gone very, very high to make it such that it's no longer profitable for them, and therefore they cannot make money? By your argument, that should also be a frustrating event.
Yes, my lord. Again, like I believe you have previously said, this is a very innovative approach towards the issue. And with innovative approach that seeks to develop or maybe extend the law, there will be times where it will inevitably create uncertainties. And that uncertainty will be up to the court as well as the solicitors to assist the court in unveiging the uncertainties, to clarify the uncertainties. I'm sorry.
All right, thank you.
Now, coming back to the facts of this case, there is nothing to suggest that the Satoshis could not afford to pay the balance of the purchase price. All that was found in evidence was that the restaurant suffered massive financial losses, but there's nothing to suggest that they were not able to perform. So how does your frustration, the extraordinary circumstances, supervening circumstances, impact on their performance of the contract?
In fact, yes, my lord, I understand your concern. And with that, I perhaps might not be able to holistically address your concern as for now. However, I do truly believe.
There is
yeah, my
and in
apologies.
fact, if I may add, it seems from the facts that the reason why your client is not paying is because they thought that it was overpriced.
To address your concern, actually, my lord, I would like to address the fact that should the appellant be bringing a claim of frustration as an excuse because he is merely frustrated emotionally or unhappy with the fact that he might have been cheated or so and so, the appellant would have a bigger chance at winning the case if he had brought it under perhaps fraud or misrepresentation. But that is not the case, because in the present case, the appellant genuinely is incapable of paying the 1 million ringgit in balance, and that is why the claim is brought under frustration.
All right.
Sorry, would you accept that the argument of frustration is a weak argument? Would you be prepared to concede that?
No, my lady, I am not prepared to concede that. That is because although given the limited information that we are handed under the fact sheet, there are many points in time where we have to make reasonable deducements. And I truly believe that the arguments that I have made today are all based on reasonable inference based on the facts. And furthermore, to extend the doctrine of frustration is not only a way to allow the law to adapt according to the society it seeks to govern, it also will allow the law to remain equitable and just in face of a global change in circumstances.
Yeah, thank you.
Well, overall, it is submitted that the doctrine of frustration should be construed liberally under modern day's context. As such, the contract should be frustrated by COVID-19 and or the various restrictions imposed as a result of it, because it has materially rendered performance economically and commercially impracticable for Satoshi. With your lordship and ladyship's permission, I would like to now submit on the fourth ground of appeal, which is exemplary damages should be awarded.
Yes.
Due to the time constraints, I will try my best to summarize the appellant's submission. So turning to the fourth ground of appeal, the appellant submits that the learned High Court judge has erred in finding for not awarding exemplary damages. Again, for the convenience of the court, the appellant will divide its submission into two parts. The appellant will first submit on the issue of conversion and then subsequently on the issue of exemplary damages. On the issue of conversion, the appellant will submit on two subpoints. That is, the appellant had immediate possessions to the goods, which entitles them to sue for conversion. And second, there is clear refusal and demand in this case to sustain the claim of conversion. To start off the first subpoint, the appellant submits that consent orders are contractual in nature and are thus essentially contracts. And with this, we can look at the case of Thong Li Hua and Chin A Kui Tong Chong Fa, where the court provided that terms of settlement incorporated into a court order okay, incorporated into a court order is binding on all relevant parties. And in the present case, the fact sheet provides that the consent judgment was recorded as a formal settlement agreement. This can be deduced from paragraph 10, where the learned High Court judge provided that a consent judgment could only be recorded if a settlement can be reached on the same day. Therefore, the consent judgment would naturally constitute a contract that is binding on both Satoshi and Phaeton under the authority of Thong Li Hua. According to clause 4 of the clarifications document, the consent judgment provides that Satoshi may collect the antiquities from Phaeton upon pronouncement of the consent judgment itself. Thus, this term itself naturally constitutes a contract binding on both parties under the authority of the federal court. The appellant will hereby, thank you, your lady and your lords, your lordships. Sorry.
Do you need a bit of time to cover the other point on exemplary damages?
Yes, my lord.
All right, do it very quickly.
Thank you, my lord. Since the consent order is established to be contractual in nature, the appellant further submits that the consent judgment would have superseded the previous sale and purchase agreement dated the 2nd of February 2020. And here we may refer to the case of Armada Singapore Private Limited and Ashapura Minecam Limited. Citing the then Justice Abdul Malik bin Ishaq, the High Court in Armada affirms that novation under Section 63 of the Contracts Act 1950 extends beyond English common law principle and covers situation when older contract is substituted by a new one. In the present case, the parties must have intended for the consent judgment to supersede the sale and purchase agreement executed on the 2nd of February, since it is effectively a settlement agreement. Given that consent judgment is already established to be contractual in nature, the authority of Armada will be applicable. As such, under Section 63 of the Contracts Act 1950, the sale and purchase agreement would therefore be novated by the consent judgment, giving the appellant the right to immediate possession of the antiquities upon pronouncement of the consent judgment.
Maybe you just want to address us as to why exemplary damages should be awarded.
Yes, my lord. In terms of exemplary damages, it is important for the court to be reminded that under Rooks and Barnard, the court provided 3 instances where exemplary damages can be awarded, which includes inter alia conduct calculated to result in profit. And turning to the case of Sambaga Valley and Datuk Bandar Kuala Lumpur, here the court awarded exemplary damages for the tort of conversion on the part of the respondent by seizure of goods. Here, the rationale was that the respondent, a public servant, had acted oppressively and unconstitutionally, which falls within the ambit permitted by Rooks and Barnard. Similarly, in the present case, the respondent's conversion amounts to a conduct calculated to result in profit. Thus, exemplary damages should be awarded by the court for the respondent's conversion, particularly since the courts in Malaysia have awarded exemplary damages. My lord and my lady, I see that you are slightly confused by my sudden claim that the respondent's conversion amounts to a conduct calculated to result in profit. Therefore, I will jump back up, refer back to the part that I had just skipped. So based on the facts of the case, the appellant had made a clear demands for the goods on the 19th of December 2020, when the appellant's representative attempted to collect the goods from the respondent's warehouse. And given that it would be reasonable to assume that the respondent's employees are aware that the appellant is entitled to the goods under the consent order that was only executed 2 days prior, there would be there would be a clear demand. And furthermore, refusal is undisputed, so there is definitely conversion on the part of the respondent. However, as can be observed, there are actually 2 limbs to this principle, 2 limbs to the principle in Broom. I'm sorry, my lady and my lords. May I just have a, sorry, yes?
You're back to the Rook and Bernard argument, right?
Yes.
Sorry, actually my confusion is it's not so much that the case that you cited just now was a case of, I think, example of oppressive conduct, right, on the part of on the authority. So this is not your argument here, presumably, right? So that's not an issue.
No.
The only issue here, I suppose, is whether or not it can be inferred that there is sort of an intention or calculated to try and sort of make profits, and that will outweigh, I suppose.
Yes.
Can you just focus on that, perhaps? Thank you.
Yes, my lady. So as mentioned, what is left to be determined now is whether the respondent's tort falls within the ambit of Rooks and Barnard, specifically whether the conduct was calculated to result in profit. And with that, we can look at the case of Broom and Castle, where it was established that exemplary damages may be awarded when the tortfeasor deliberately committed the tort, despite the possibility of having to pay damages because he believes that it will nonetheless work out satisfactorily for him. And as can be observed in our current case, as can be observed here, there are two limbs to the principle of Broom. That is, first, calculation, and second, satisfactory outcome. So here, the defendant's calculation can be deduced from its deliberate act of seeking to set aside the consent judgment and subsequently reinstate its action against the appellant to claim the balance 1 million ringgit. And furthermore, the respondent must also have viewed the combination of these two attempts to be profitable or satisfactory for them, since either way, they would be in possession of the antiquities that are worth 2 million ringgit, or they may get 1 million ringgit in damages under the reinstated action. Since the consent judgment was executed 2 days before collection was refused, there is sufficient time for the respondent to ponder on its decision and their subsequent decision to convert the antiquities and reinstate its legal actions appear to be an attempt to reverse their predicament. That, my lady and my lords, concludes the submission that I wish to make for the appellant. Is there anything I may assist you all on?
Nothing from me, thank you.
Fine.
Fine with me. Thank you very much.
Thank you.
Before I begin, I would like to confirm if I'm audible to my lords and my lady.
Yes.
Much obliged. May it please the court, my name is Keanu and I appear as the lead counsel for the respondent in this case, which is Phaeton, along with my co-counsel, Ms. Joey Tan. I will address the first and second issue, while my co-counsel will address the third and fourth issue. We will be allocating 20 minutes for the first issue and 20 minutes for the third and fourth issue, while reserving 5 minutes for our Surrebuttal. Now, before I begin with my submission, the respondent would like to inform my lords and my lady that reference will be made to the Moot problem question and the correction and clarification for our submission. Now, as regarding the first issue, it is necessary for me to clarify that there are two parts for the first issue. The first part would be regarding the applicable test for legal advice privilege in Malaysia, and the second part would be to determine whether the correspondence ought to be deemed privileged. Now, I'll begin by submitting on the first part of this issue, which is that the applicable test for legal advice privilege in Malaysia should be the test as laid down in the case of Balabal against Air India, as rightfully decided by the High Court, and not the dominant purpose test as laid down in the English Court of Appeal case of Jet2.com. There are two grounds to support my argument. Firstly, the Malaysian court have adopted the test in Balabal against Air India, and there are no Malaysian courts which have adopted the dominant purpose test as laid down in the Jet2 case. I would like to bring my lords and my ladies' attention to the recent Malaysian Court of Appeal case of Malaysian Debt Ventures Berhad against Platinum Taxol Sendirian Berhad. Now, in this case, the appeal is against an order of discovery of a draft settlement agreement. It was argued on behalf of the respondents that the legal advice must be the dominant purpose for the creation of the draft settlement agreement. However, the court stated that it is clear that the answer to the nagging question of whether legal professional privilege attaches to the draft settlement agreement is to ask whether the test laid down in Balabal was fulfilled. Now, therefore, since the recent Court of Appeal case has decided to remain with the Balabal's test even after considering the dominant purpose test from Jet2, this clearly shows that the Malaysian court has deemed it unnecessary to adopt the dominant purpose test. Now, the learned opposing counsel has mentioned that the dominant purpose test has been adopted in other common law countries, including countries such as Singapore. However, the respondent submits that not all common law countries have incorporated this test into their jurisdiction. For example, in the Singaporean Court of Appeal case of Skandinaviska and Skilda Banken against Asia Pacific Breweries, the court merely stated in obiter that the dominant purpose test should be used for policy reasons. Now, moving on to my second ground, it is submitted that the dominant purpose test is redundant. To support my argument, I would like to bring the court's attention to the English Court of Appeal case of Director of the Serious Fraud Office against Eurasian Natural Resources. In this case, the court considered that the purpose which had to be dominant was unnecessary and tautologous, as legal advice privilege can only be claimed when legal advice is being sought or given. Moreover, the English House of Lords case of Three Rivers District Council against Governor and Company of the Bank of England No. 6 has cited the Balabel's case with approval and declined to import the dominant purpose test. The House of Lords emphasized on the need for a relevant legal context and provided that to extend privilege without limit to all solicitor and client communication upon matters within the ordinary business of a solicitor and referable to that relationship would be too wide. Therefore, this suggests that the requirement for a relevant legal context in Balabel is already a sufficient filter to prevent the scope of legal advice from being too wide and from being abused. However, with full transparency to this court, it is admitted that the Jet 2 case has already given their reasons as to why these cases were not sufficient authorities to prevent the dominant purpose test from being adopted in the UK. Nonetheless, since the English Jet 2 case is also merely persuasive to this honorable court, the respondent urged that my lords and my lady to consider the authorities that have been referred to and find that the dominant purpose test to be redundant. Now, before I proceed to the second part of the first issue, does my lords and my lady require any clarifications?
Why do we have to be bothered by common law decisions in English decisions or Singapore, when we have our own legislation and Section 126 of the Evidence Act?
Yes, my lord. Now, to answer your question, my lord, the Federal Court case of Public Prosecutor against Haji Kasim has stated that the only relevant provision in our Evidence Act 1950 governing professional privilege is Section 126. Now, with that being in mind, the Malaysian court has incorporated the Balabel's test instead of the dominant purpose test. Therefore, this may suggest that the Balabel's test is in line with the Section 126 of our Evidence Act. Does that answer my lord's question? Yes.
Is it, or isn't the Section 126 even wider?
Yes, my lord.
126 actually refers to all communications, isn't it?
Yes, my lord. However, Section 126 is silent as to what form of communication will be protected by the legal advice privilege. Therefore, the Malaysian courts has looked towards the English common law for guidance.
Doesn't the silence exclude any imposition of qualifications? When the section when the statutory provision does not qualify the nature of the communication, should we be trying to qualify it by using common law principles?
My lord, to answer your question, the respondent would like to again bring up the 2020 Court of Appeal case to answer that question in affirmative, that we should look towards the English common law for guidance. Much obliged.
May I ask, Section 126 precludes an advocate and solicitor from disclosing privilege material. The prohibition is against the advocate and solicitor only, right? Not against the party, if I were to sort of look at it very literally. Would you agree with that?
My lord, my lady, my apologies, my lady.
The last time I checked.
Apologies, my lady.
Okay, I'm just looking at the provision literally. It says, I think it precludes no advocate shall at any time be permitted. So the prohibition against disclosure is targeted at an advocate only. So does
Yes.
it mean that your client, therefore, is at liberty to disclose? They're not, they're not precluded. It's the advocate and solicitor that is prohibited. Is that correct? Would you?
Yes, my lady. My client will have the liberty to waive this privilege, as it is mentioned in section 126, that only the client has the power to do so.
So therefore, your client is not prepared to waive. Is that correct?
Yes, my lady.
Could waive but not prepared to waive.
My lady, as the facts of the question does not mention, the respondent would submit that our client is not willing to waive such privilege, as there are no reasons to do so.
Well, no reason has been given. Can we make the inference, therefore, that because your client is not prepared to waive, the inference is that there may be something, I'm just making the inference now, damaging in that correspondence that could be adversely inferred against your client? Would that be a fair way to put it? Because your client is not precluded from disclosing the information if they wish to.
My lady, to answer your question, I would like to refer my lady to the federal court case of Dato Anthony C. Tiao Guan against C. Tiao Guan Chuan and another. Now, in this case, the court stated that the rationale for the privilege is to allow a man to be able to consult his lawyer in confidence. The court has also cited the Privy Council case of B against Auckland District, which provided that the refusal of the claimant to waive his privilege for any reason or none cannot be questioned or investigated by the court. Therefore, the respondent submits that the respondent would not be required to do so, and my lady would be, apologies, my lady, and the court will not be allowed to make such negative inference from our client's refusal to waive its privilege. Does that answer my lady's question?
I will take that under consideration. Thank you.
Perhaps the suggestion here is section 129 and not 126 because discovery is against Python.
I was going to, yes, I think it's 129. Have you looked at 129?
Yes, my lady and my lord.
The address is on 129 then, if you've looked at it.
My lady, I believe that section 129 provides that the respondent would have the respondent will not be obligated to disclose the correspondence as privilege. Therefore, the section 129 is in the favor of the respondent to refuse discovery from the appellant.
So my understanding of 129, if the court feels the disclosure is necessary, the court could compel your client to make the disclosures. Would you agree with that? If it's necessary.
Yes, my lady. However, section 129 also provides that only when the client is being asked to as a witness, which is, I believe, the facts of the case does not state so.
So who was the witness here then?
My lady, as the facts of the questions are definitely limited on this part, I would not, the respondent would not draw any inference to answer my lady's question.
Anything else? Any other points you're making?
Yes, my lord. Now moving on to the second part of the first issue, which is to submit that the correspondence should be deemed privileged under the Balabel's test, as the correspondence is made for the purpose of seeking legal advice in the relevant legal context. Now, to support my argument, I would like to bring my lords and my ladies' attention to the Balabel's case, which provides that the test is whether the communication or document was made confidentially for the purpose of legal advice in a relevant legal context. The court has also propounded that the privilege will attach to communication where information is passed by the solicitor or client to the other as part of the continuum aimed at keeping both informed so that advice may be sought and given as required. Now, in applying this principle, it is submitted that the correspondence where Chye and Co. contacted Phaeton is a continuum of communication from the weeks of settlement negotiation. May I refer my lords and my ladies' attention to paragraph 9, second line of the facts of the case? Much obliged. It is stated that the parties were close to reaching a settlement after weeks of settlement negotiation. And in the following paragraph, paragraph 10, the learned High Court judge informed the solicitors that the consent judgment could be recorded on the same day if a settlement could be finalized. Therefore, the objective of the contact between Chye and Co. and Phaeton after the court was adjourned was to keep each other informed on the progress of the settlement, so that advice may be sought and given as required by Phaeton prior to the recording of the consent judgment. Now, due to this continuum of communication, privilege will be attached to the correspondence between Chye and Co. and Phaeton. Now, before I proceed to submit my submission on the second issue, does my lords and my lady require any clarifications? Much obliged.
From me, yeah.
Much obliged. Now, moving on to the second issue, the respondent submits that the consent judgment should be set aside for want of consent and access of authority on Chye and Co.'s part. There are two grounds for my submission on this issue. As for my first ground, the respondent submits that the consent judgment should be set aside as there was no meeting of mind between Phaeton and Satoshi. To support my argument, I would like to refer this court to the federal court case of Khao Po Chuan against Ng Ngai Peng. Now, in this case, the court stated that a perfected consent order can only be set aside in a fresh action filed for the purpose, and it can be set aside on the same grounds as those on which an agreement may be set aside. Now, in another federal court case of Badiadin Muhammad Mahidin, the court stated that the grounds referred to for setting aside a consent judgment are grounds which basically relates to consensus ad idem or the free consent of the parties to a binding agreement. Now, with reference to the authorities that I have mentioned, it is submitted that on a balance of probabilities, the facts of our case strongly suggest that there was no meeting of mind between Phaeton and Satoshi when the consent judgment was recorded. To support this argument, I would like to bring my lords and my ladies' attention to paragraph 9, 6 line of the facts of the case.
Yes.
Much obliged. Here, it is stated that the representatives from both Phaeton and Satoshi were not present in the court when the consent judgment was recorded. Now, this means that Phaeton and Satoshi could not have possibly discussed with each other regarding the consent judgment. Therefore, the consent judgment...
Does the council represent the parties?
Yes, yes, my lord. The authority which stated that that the solicitor represent the client is from the High Court case of Liao Xing Huat against Lau Mui Yen, which I will be addressing on my second ground. However, I'll be addressing on now since my lord has mentioned that principle. As mentioned, the principle that the solicitors has an implied authority on their client's behalf is from the High Court case of Liao Xing Huat. However, the respondents submit that access of authority on the solicitor part is a ground to set aside the consent judgment, as grave injustice would be suffered by Phaeton if the consent judgment was not set aside. To support my argument, I would like to bring my lord and my lady's attention to the High Court case of T. Devendran Analalaki and Tachnamurti. Now, in this case, the court decided that absence of authority on the part of the council was a ground for setting aside a consent judgment and expressly refused to follow the principle as laid down in the Liao Xing Huat case.
Sorry, Council, I'm so sorry, may I interject?
Yes, my
I'm
lady.
just troubled by the fact that on the one hand, you're saying that the argument against implied authority is that as long as one can demonstrate that the lawyer has acted without authority, basically, or in excess of authority. But if you're refusing, or your client is refusing to disclose the correspondence, how is the court going to be satisfied that the instructions from the clients were to settle or not to settle? Because your client is not waiving that privilege. So what material is there before the court to decide that there has been excess of authority, if that's the argument that you're taking to respond to the implied authority argument? Could you
Yes,
perhaps
my lady.
address that? Thank you.
Yes, my lady. To answer my lady's question, the evidence that access of authority, that there was access of authority on the Phyton's former solicitor could be inferred from the facts of our case, where on a balance of probabilities, it strongly suggests that there was access of authority on their part. May I refer my lords and my ladies' attention to paragraph 11, the second line of the facts of our case.
Yes, what does it say?
It states that Phyton's representative barred Satoshi's representative from entering the premise 2 days after the consent judgment was recorded. Now, this shows that Phyton has protested against the consent judgment. My lords and
change their minds. Sorry, isn't it?
Apologies.
2 days later, they thought they had a bad deal. But I mean, doesn't mean that at that time they.
It's after the event. It's after the consent order has been recorded.
Yes, yes, my lord and my lady. However, it is also possible, as mentioned by the opposing counsel, that that the terms would be similar as the terms negotiated a few weeks prior. However, this is not stated in the facts of the case. It is not stated that the terms are same as during when the negotiation talks were in place.
But the council would have the authority, isn't it, to enter into terms which their team works in the benefit of their clients.
However, if such inference was made, it would only be fair to also assume the possibilities that the solicitors had introduced a new terms that was not there in the first place during the
And what is wrong with that? What is wrong with the solicitors introducing a new terms if they have an implied authority to do so?
However, my lord, that would be against the will of our client.
But there is no evidence of that.
Yes, my lord. My lord, I see that my time has lapsed. May I request for a few minutes to wrap up my submission on this issue?
Yes. Yes, proceed.
Much obliged, my lord. My lord, I would like to refer back to the second ground of my argument, which is that the access of authority is a ground to set aside the consent judgment as grave injustice would be suffered by Phyton. Now, it is stated that the High Court case of T. Devendran has refused to follow the Liao Seng Huat case and decided to follow the Federal Court case of S. Pakyanathan against R.K. Stallet. Now, in this case, the Senior Assistant Registrar made a consent order that the appellant pay the $42,000 as damages. The appellant thereupon applied to have the order set aside, as he stated that the solicitors had no authority to give consent and that there was no sufficient evidence relating to the damages. Now, the federal court cited the English Court of Appeal case of Marsden against Marsden and stated that the court has a discretion to set aside the consent order where grave injustice would be done by allowing it to stand. Now, with this principle, the court considered the circumstances of the case and decided that there would be grave injustice if the consent order was allowed to stand. Applying the principle as mentioned, the court has considered that the appellant was not present for the inquiry for assessment of damages, and the appellants could not have been in a position to agree to anything, as the appellant was unaware or had not been in possession of material facts. Therefore, the appellant's former solicitor must have made a mistake. And thirdly, the court also considered that the assessment of damages was founded on inadmissible evidence, such as hearsay evidence. Now, this is similar to the facts of our case. May I bring my lords and my ladies' attention to paragraph 9, 6th line of the facts of the case?
Yes.
Much obliged. Here, it is stated that representatives from both Phaeton and Satoshi were not present in the court when the consent judgment was recorded. Next, as mentioned earlier, Phaeton is likely to have only known about Chye and Co.'s unauthorized act when Satoshi's representative arrived to collect the goods. Therefore, it is likely that Phaeton's former solicitors had mistakenly believed that they were authorized to consent to the consent judgment. Moreover, it is stated in paragraph 6, the fourth line of the facts of the case, that the goods were alleged to be only worth R1 million is based on a hearsay from a friend of Mr. Daniel, namely Paul Senai. If the consent judgment was allowed to stay, this would essentially cause Phaeton to suffer great loss, in which the impact would be greatly amplified during this current pandemic situation. Moreover, it would eventually allow Satoshi to go back on their promise of agreeing to purchase the goods for 2 million ringgit. Therefore, in considering the cumulative of facts as a whole, it is submitted that Phaeton will suffer grave injustice if the consent judgment was not set
Phaeton
aside.
can have a remedy against their own counsel for acting in excess of authority, isn't it?
Yes, my lord. However, that principle was laid down in the High Court case of Liao Seng Huat, and it is not binding on the appellate court.
But whether it's binding or not, don't you agree that they have a remedy?
Yes, my lord. It is possible that Phaeton may bring an action against their former solicitor.
So isn't that good enough for your client? They have no laws. They can go after their counsel.
However, my lord, this would allow the Satoshi to walk away with the goods with only half the price based on the hearsay evidence.
But your clients would have gotten their remedy against their counsel. The fact that, you know, Satoshi is able to get the goods now at only 1 million, why should that matter?
Yes, my lord. As mentioned that in considering of the cumulative effects of our present case, and with the points that I have mentioned earlier, there would be grave injustice if the consent judgment was.
Where is a grave injustice if they can recover from your counsel?
My lord, one of it would be the fact that the appellant would be allowed to go back on their promise of agreeing to purchase the goods for 2 million ringgit.
If you speak of his injustice, whose fault is it at the end of the day? Is it counsel, the client, or the other side?
My lord, to answer the question, I believe that it would be on, default would be on the part of the solicitor, the former solicitor.
So why should the selling party suffer any injustice? Why can't the remedy, why can't the compensation or the damage be compensated by the party at fault for the justice of the case, as you say? Which is the solicitor, as Justice Ong suggested. That is what the fair, just situation should be, isn't it?
However, my lord, it would be injustice for Phaeton if the Satoshi would be allowed to walk away with the goods of 1 million based on a hearsay evidence. Wouldn't it?
Anything else?
No, my lord. That concludes. I would proceed to conclude my submission on the second issue.
Yes.
Now, in conclusion, the respondent submits that the consent judgment should be set aside on the grounds of one of consent and excess of authority on Chye and Co.'s part, as there was no meeting of mind between Phaeton and Satoshi, and that there will be grave injustice suffered by Phaeton if the consent judgment was not set aside. I will now pass the time to my co-counsel, Ms. Joey Tan, to submit on the third and fourth issue.
Thank you.
Much obliged.
May it please the court, my name is Joey Tan, the junior counsel for the respondent, Phaeton. I will now address the court on the third issue, where the agreement is not frustrated. I will be addressing 3 grounds in my submission. The first ground, The agreement is not frustrated as the event did not render the appellant's contractual obligations impossible. As addressed by my learned opposing counsel, the doctrine of frustration is governed under Section 57 sub 2 of the Contracts Act. However, the word impossible within this ambit of Section 57 sub 2 is not defined in the Act. As such, its meaning has to be referred to case law. In my submissions, I will be addressing two interpretations of the word impossible. The first interpretation of impossible refers to an obligation becoming radically different from what was originally undertaken. This proposition is supported by the Federal Court case of Ramli bin Zakaria and others against the Government of Malaysia. In this case, the Federal Court adopted the principle in the House of Lords case of Davies Contractors Limited against Fareham UDC, where Lord Radcliffe propounded that a contractual obligation had become incapable of being performed when the frustrating event rendered it radically different from what was originally undertaken. My lords and my lady, in the present case, the appellant's contractual obligation can be found in paragraph 4, which is to pay the remaining balance of 50% purchase price once the antiquities have been delivered to them. And the frustrating event here in the case, as rightly addressed by my learned opposing counsel, is that the frustrating event refers to the SOP imposed by the government to curb the spread of COVID-19. It is submitted that this frustrating event did not render the appellant's obligations to pay radically different from what was initially agreed in the agreement. This is because with or without the SOPs imposed, the appellant's obligations remains the same, which is to pay for the remaining 50% balance of the purchase price. As such, the supervening event did not cause a radical change to the appellant's obligations. Moving on to the second interpretation of impossible, the Federal Court case of Pacific Forest Industries Sendram Berhad and another against Lim Wen Chi and another. In this case, former Chief Justice Zaki bin Tun Azmi propounded that a contract is frustrated when a change of circumstances renders the contract legally or physically impossible to be performed. My lords and my lady, in this present case, the frustrating event, i.e. the SOP imposed, did not render the appellant's obligation physically or legally impossible to be performed. This is because under the Prevention and Control of Infectious Disease Measures Within Infected Local Areas Regulations 2020, the banking and finance sector is regarded as an essential service, and they can remain open during the Movement Control Order in March 2020. As such, legally and physically, the appellant is still able to perform their obligation to pay the remaining balance. Moreover, online transactions are also available for them to perform their obligations. As such, based on the two interpretations submitted, the event did not render the appellant's obligations impossible within the ambit of Section 57 sub 2 of the Contracts Act. This is because the event had not rendered the appellant's obligation radically different, legally impossible, or physically impossible to perform. Before I move on to the second ground, does my lords and my lady require any assistance?
Well, whilst I agree that the performance itself is not radically different, the performance of the obligation is not radically different, do you think that it should actually extend to the fact that the ability to perform is now radically different? Do you understand my question?
If I may...
The counsel from the appellant suggested that
yes,
because of the SOP, because this is one in a century event where, you know, it is completely unexpected, it has now radically affected the appellant's ability to pay financially. They are just incapable of paying. So do you think that the fact that performance of the obligation is not radically changed, but the fact that the ability of the party to perform is now radically changed, that should of itself suffices to create a frustrating event?
My lord, if I may receive your question correctly, is your lordship asking if the ability to perform has radically rendered radically different from what was initially agreed? Is that a ground to frustration?
Yes, the fact that the appellant now is insolvent, he has no money to pay already.
Yes, my lord, Under section 57 sub 2, the radically different element refers specifically to the contractual obligation. However, in reference to the ability to perform, this is exactly what I'm about to address in my second ground.
All right.
Is a mere difficulty to perform is not a sufficient ground to render the entire agreement frustrated. And this proposition is supported by the Court of Appeal case of Sentul Raya Sendram Berhad against Hariram Jayaram and other appeals. In this case, Court of Appeal Judge Gopal Sriram, as he then was, cited the Court of Appeal case of Ocean Tram Tankers Corporation against V.O. Zevraj. In this case, Lord Denning propounded that a performance of a contract has become more onerous or more expensive is not sufficient to bring about frustration. Moreover, in the Federal Court case of Pacific Forest Industries Sendram Berhad against Lim Wen Chin, former Chief Justice Zaki bin Tun Azmi also propounded similarly that a contract does not become frustrated merely because it becomes difficult to perform. His Lordship further explained that if a party has no money to pay his debt, it cannot be considered to be impossible to perform. May I refer my Lords and my Ladies' attention to the facts of the case, paragraph 6, 3rd to 4th line. Here it says that due to the SOP imposed, Satoshi's chains of restaurants suffered a massive financial loss. It is evident here that the appellant had a mere financial difficulty in performing his contractual obligation, which is to make payment of the remaining 1 million. This mere difficulty to pay is a mere commercial hardship, which is insufficient to render the entire contract frustrated. As such, the appellant's claim of frustration cannot stand.
All right, thank you.
Can I interject?
Yes, my lady.
Would you accept that none of the cases that you're able to put before this court will have similar facts with this pandemic situation, because it is quite radical, if I may use the term that you used just now. I don't think it may perhaps be a bit unfair to say this is a mere financial hardship situation, isn't it? Because with the SOPs, restaurants were closed for many months, and I don't think it's completely unprecedented, if I may use those terms. So given this radical, unprecedented set of circumstances, this is not a mere economic hardship, a mere normal financial, somebody not taking care of their cash flow issue that perhaps the courts are used to seeing. This is a pandemic, worldwide restaurants closed for many months, resulting in this particular restaurant not having the income to pay, basically. So it is quite different. So I think any case that you may cite, I doubt very much will fall, on all fours with the facts of this case. But I'm wondering, with that, with the distinguishing factors we see here, can it be argued that this is that radical change? This is the case where not a mere economic hardship, but really unprecedented facts that we can therefore trigger the doctrine of frustration. Could you address that? Just the radicalness of the situation.
Much obliged, my lady. In reference to the issue of frustration, there are certain elements to be proved, and the fact that the ability to perform has been radically changed and been radically become more onerous to perform is not a ground to frustration. And if I may submit something that I did not intend to put in my submissions, to be honest, as rightly pointed out by my lady, that this whole COVID situation has caused many restaurants, financial and commercial sectors to have suffered massive losses. However, in reference to these financial losses, actually, the appellant can rely on Section 7 of the COVID Act, which provides them a temporary relief for such inability to perform. As such, I believe that there is a protection that is available out there for defaulting parties like the appellant. However, in this case, the appellant is averring that the entire agreement is frustrated, in which the effect of frustration is very drastic, as stated under Section 57 sub 2, that if a contract is frustrated, the entire contract is void. As such, I believe that due to a radical change of the inability to perform is insufficient to render the contract frustrated. And this is supported by the Federal Court case of Pacific Forest.
All right, move on.
Did I answer my lady's question accurately?
Yes, thank you.
Much obliged. I will now move on to the third ground of my submission. The agreement is not frustrated as the supervening event is foreseeable. In the High Court case of Papannavan Anak Lelaki Arunasalam against Anwarul Haq bin Ahmad and others, here the court propounded that the supervening event must be unforeseeable and vitiated entirely by external factors. In the present case, the frustrating event, i.e. the SOP imposed, is foreseeable at the time the contract was entered into on 2nd February 2020. This is because at that time, COVID-19 was already present in the country. As reported by Kementerian Kesihatan Malaysia, KKM, the first case of COVID-19 was detected in Malaysia on the 25th of January 2020, which is before the contract was entered into. Moreover, the SOP imposed is foreseeable as reference could be made to other countries. For instance, China, in which the country was originated from, was already in the nationwide lockdown during February 2020. By referring and looking at how other countries have dealt with this unprecedented virus pandemic, one could foresee certain SOPs being imposed in hopes to curb with this pandemic. Does my lady require any assistance? Much obliged. To conclude the third issue, the appellant's claim of frustration holds no basis. This is because the agreement is not frustrated as a result of COVID-19, because firstly, the event did not render the appellant's obligation impossible to perform. Secondly, the event merely rendered the appellant's obligation more difficult to perform. And thirdly, the frustrating event was foreseeable. I will now move on to address the fourth issue, in which exemplary damages should not be awarded to the appellant. I will be only addressing one ground to this issue. Exemplary damages should not be awarded here as it does not fall under the Lord Devlin's three categories as established in Rooks and Barnett. Due to time constraint, I will only be addressing the second category and explain why they are not applicable here in this case. The second category established in Rooks and Barnett consists of an exemplary damages may be awarded if the defendant's act in disregarding the plaintiff's right has been calculated to bring in profit which exceeds the compensation payable to the plaintiff. This category does not apply here because Phyton's thought of conversion had not been calculated to bring in the profit. May I refer my lords and my ladies' attention to the correction and clarification? Question 19. Here it says that the thought of conversion is based on the consent judgment, which provides that Satoshi is to collect the goods from Phyton. As such, the thought of conversion occurred because Phyton refused to let Satoshi collect the goods. As submitted by my learned co-counsel earlier, the respondent did not consent to the consent judgment. And if a person had not consented to something, it is only logical and natural for them to not abide by something that they did not consent to. The reason why I am bringing up this point is because the respondent's act of holding on to the goods is mainly because he did not consent to the consent judgment and not because he had calculated to bring in a profit. Moreover,
assuming that the court finds that the consent judgment was agreed to, does that make a difference to your argument?
No, my lord. This is because Malaysian case laws have shown that exemplary damages are generally not awarded in thought of conversion cases. In the High Court case of KFH Sejarah House Sendram Berhad against Lembaga Kemajuan Wilayah Pulau Pinang, in this case, the defendant had seized the plaintiff's machine and auctioned it. The court held that, yes, there was conversion, but had only granted compensatory damages. Exemplary
but the facts here are different, isn't it? The facts here are different, right? Assuming that the consent judgment was agreed to by your client,
yes,
then argument has been made that the reason why they are refusing to give possession was to enable them to set aside the consent judgment so that they can reinforce or enforce on the original contract to receive a sum of 2 million. Because under the consent judgment, it appears, at least from the facts, that your clients only get 1 million.
Yes, my lord.
Yes. How do you argue against that? That there is a profit element in your client's action to retain possession and not give up possession?
My lord, if I have received your question correctly, is your lordship asking as to how I can prove that the respondent had not calculated to bring in a profit by committing the tort of conversion?
That's right.
Yes, my lord. This, in order to answer your question, I would have to refer back to the second issue, which was addressed by my learned co-counsel, in which the respondent did not consent to the consent judgment. As such, the act of withholding the goods is not a malicious intention to...
No, I'm saying, assuming that the court is satisfied that the consent order was agreed to.
Yes.
Therefore, the withholding of possession, can it not be argued, is malicious or at least with an intention to profit? And therefore, exemplary damages should be awarded.
Yes, my lord. In the event if the court is satisfied that that the respondent had calculated to bring in the profit.
No. The assumption now is there is a consent judgment.
Yes.
Take it from there. So that means if the consent judgment is valid, it's not going to be set aside. So therefore, the inference that the court is being asked to make is that your client does not want to agree or doesn't to allow the goods to be released, although it should under the consent judgment. So there is then an inference that it is the reason for the non-release is because it wants to make a profit, wants to make money and hold on to the goods, basically. So what is your response to the court making that inference?
My lady, I believe that in order to as cited in the 2019 Court of Appeal case of Tradeswind Properties against Zulkifli Avar, the court stated that in claiming exemplary damages under the second category of Rooks and Barnett, the plaintiff must prove that the defendants have made a profit for themselves. As such, the onus of proof here lies on the appellant to prove that the respondent have indeed calculated to bring about a profit by committing the tort of conversion.
So sorry, I don't think there's a need to prove there's profit, but it's calculated.
Yes, my lady.
It is done with a view of making a profit or financial gain. I don't think there's a need to prove that the profit was in fact made. So
yes,
can we say that here that there was it was done with a view of making a financial gain by not wanting to exceed or comply with the consent judgment?
No, my lady. The respondent retains the submission that there is no malicious intention to bring about more profit in the tort of conversion. Yes.
Your contention as you've submitted was that the reason was he did not agree to the consent judgment.
Yes.
That was his reason rather than profit making. Is that your contention?
My lord, in order to satisfy the second category of Rooks and Barnett, one has to show that the tortfeasor has calculated, has had bad intentions, malicious intentions in committing that tort, which is to bring in more profit. However, the respondent submits that because he did not consent to the consent judgment, that's why as a protection of the respondent's interest, the respondent had committed the tort of conversion.
So you are saying that it is the disagreement that he consented to the consent judgment rather than the objective of making a profit.
Yes, my lord.
All right, anything else?
May I request for an extension of 2 minutes?
Yes.
Much obliged, my lord. Besides the second category in Rooks and Barnett, Malaysian case laws have shown that exemplary damages are generally not awarded in tort of conversion cases. Reference will be made to 2 cases. In the High Court case of KFH Sejarah House, the defendant had auctioned the plaintiff goods. The court held that there was tort of conversion, but exemplary damages were not granted. In another High Court case of Chin Bui Kiat, the defendant had attempted to sell the plaintiff's good and deprive the plaintiff of its use and possession for 5 years. Similarly, in this case, the court held that there was conversion, however, no exemplary damages were awarded. In the present case, my lords and my lady, the respondent had merely held on to the goods. And comparing the severity of the respondent's conduct in this case to the both cases cited earlier, it is evident that the respondent's conduct is not one that is so outrageous to the point that it attracts exemplary damages. As such, the respondent submits that exemplary damages is not to be awarded to the appellant. In concluding the 4th issue, exemplary damages should not be awarded as none of the Lord Devlin's categories in Rooks and Barnett applies, and Malaysian precedents have generally not awarded exemplary damages for this tort. In conclusion of the respondent's submission as a whole, it is submitted that firstly, the correspondent was protected by legal advice privilege as it came into existence in a relevant legal context as per the case of Balabel. And secondly, the consent judgment should be set aside for want of consent of the respondent and the excess of authority on Chye and Co.'s part. Thirdly, the agreement is not frustrated. And fourth, exemplary damages should not be awarded. If the court requires no further assistance, this concludes the respondent's submission. And I pray that the court will find in favor of the respondent and dismiss the appeal accordingly. Much obliged. Yes, my lord.
Are you suggesting the court should ignore the fact that an individual may disregard an order of the court before it's set aside?
No, my lord.
And if a party disregards the order of a court, don't you think, knowingly disregards the order of a court before it is set aside, don't you think some form of punitive damages should follow?
Yes, my lord.
And do you think that this is such a case?
Unfortunately, my lord, if I may be honest, the facts of the case suggest so.
Do you have authority to say that?
to say that if a consent order is disobeyed, then exemplary damages may be awarded.
So you consider there's a problem there?
That's a very astute observation by Justice Goon. So, yeah, under circumstances like this, shouldn't we award exemplary damages? Yes.
Yes, my lords. However, we wish to emphasize on the fact that the respondent did not intentionally disobey the consent judgment. As in reference to my... Yes, my lord.
Are you suggesting he accidentally disobeyed?
Rather than accidentally, I would say that he had no knowledge that such a the consent judgment had been recorded. He had no knowledge of the existence of the consent judgment as a whole.
So you're saying it goes to his state of mind?
Yes, my lady.
To add?
Much obliged.
That's it? Nothing else to add?
No, my lord. That concludes my submission. Much obliged.
Right. Any rebuttals?
May it please the court. The appellant have few points for rebuttals.
Yes.
With your lordship and ladyship permission, I'll start submitting my first point. Our learned friend has cited the case of Malaysian debt venture Berhad and platinum tax of Sendam Berhad. And our learned friend submits that in this case, the court appeal judge S. Nathan Balan had preferred the broad purpose approach. However, His lordship in his judgment did not expressly rule that the dominant purpose task has no role to play in Malaysia. In fact, his lordship, when adopting the broad purpose task, did not give any reason that why dominant purpose task was not applied in that case. Despite that, he actually noticed that there was such a task. Therefore, this case, which is the case that our learned friend have mentioned, this does not conclusively rule that dominant purpose task does not apply in Malaysia. Therefore, it still remains open for applications. Secondly, the appellant would like to reinstate that the dominant purpose of the correspondent here is to sort authorizations. The case of Cullen and Cullen, which supports that a mere inquiry about authorizations of solicitor is not privileged, and this case was actually cited with approval in the case of Bellbow and Air Indian. So therefore, whether applying dominant purpose task or the broad purpose task, correspondence regarding authorizations will not be protected by legal advice privilege. Thirdly, if the consent judgment is truly entered into by the mistake of their previous solicitors or in excess of authority of their former solicitors, they should take action against their previous solicitor under negligence instead. It will be very selfish for them to set aside the consent judgment here. When the appellant has entered into the consent judgment in good faith, the appellant should not be punished because of respondent solicitor's mistake. Fourthly, the consent judgment should not be set aside easily because it will cause floodgates issues. It will leave an expression or impression that the clients could conveniently, especially when they change their mind, orchestrate with their lawyers the same argument to set aside consent judgment. And this will undermine a properly recorded consent judgment and brings great inconvenience to the court. Regarding the issues of conversion, firstly, on the issues of conversion, the appellant submits that the conversion is established here because the consent judgment is contractual in nature and has thus supersedes the previous sales and purchase agreement made on the same subject. Since consent judgment grants the appellant the right to immediate possession of the antiquities, respondents' refusal to deliver up the goods upon demand amounts to evidence of conversion. Secondly, in response to our learned friend's submission that exemplary damages is not awarded for conversion, the respondent reiterates that the case of Sambaga Valley, Ponusami, and Datuk Bandar Kuala Lumpur have awarded exemplary damages for tort of conversion on the part for the respondent by seizure of the goods. Our learned friend also submits that exemplary damages should not be allowed because there is no calculation to result in profit. However, the appellant wishes to reiterate its previous submission on the subject matter. The defendant calculation can be deduced from its deliberate act of seeking to set aside consent judgment and reinstate its action against the appellant to claim the balance 1 million. Furthermore, the respondent must have viewed the combination of these two attempts to be profitable or satisfactory for them, since either way they will either be in possession of the antiquities, which were 2 million, or they success in setting aside a consent judgment and get 1 million. Therefore, it could not be said that they are not calculating to result in profit. That concludes the submission, the rebuttals that I wish to submit on behalf of the appellant.
Thank you.
Much obliged, my lord and my ladies.
Any surrebuttal?
May it please the court, the respondent will now rebut to 3 points. The first point, the appellant submitted that the dominant purpose test should be the applicable test. However, in a recent Court of Appeal case of Malaysia Debt Ventures Berhad against Platinum Textiles Syndrome Berhad, in this case, the Court of Appeal has considered the dominant purpose test, but nevertheless decided to remain with the Balabel's test. This clearly shows that the Malaysian court has deemed it unnecessary to adopt the dominant purpose test. Moreover, the appellant submitted that the correspondence is not privileged as the correspondence does not contain any legal advice. However, the respondent submits that the correspondence should be deemed privileged as it is a continuum of communication between Chye & Co. and Phyton regarding the settlement and the consent judgment, which consists of legal advice being given or sought in a relevant legal context. The second point. In my learned opposing counsel submission, the appellant Satoshi claimed that the court should adopt a more liberal approach to consider impracticability in the issue of frustration. However, my lords and my lady, the impracticability point here submitted by my learned opposing counsel is one that is derived from case laws and academic references. On the other hand, the impossibility element which is addressed in my submission must be given priority. The reason for this is because it is entrenched statutorily in Section 57, Sub 2 of the Contracts Act. Moreover, the appellant had not addressed in their submissions as to how the frustrating event had rendered the appellant's obligation impossible to perform within the ambit of Section 57, Sub 2. As such, the respondent hereby submits again that the event did not render the appellant's obligation impossible to perform. Hence, the contract is not frustrated. Thirdly, in regards to the issue of exemplary damages, I have cited this case earlier, which is the 2019 Court of Appeal case of Trade Winds and Properties, in which the court stated that the plaintiff must be able to prove that the defendants have made a profit from themselves when claiming for exemplary damages under the second category. I'm aware that my lady have brought up the point that it need not to be a literal arithmetical calculation of profit as long as they have foreseen certain material advantage by committing that tort, that would suffice. However, in my learned opposing counsel submission, the appellant has failed to prove that the respondents have foresee or have calculated in some way that kind of material advantage when committing the tort of conversion. As such, the exemplary damages should not be awarded to the appellant as it does not fall under the second category of Rooks and Barnett. Hence, in light of our submissions, we pray that the court will find in favor of the respondent. And if the court requires no further assistance, this would conclude the respondent's rebuttals. Much obliged, my lords and my lady.
Thank you.
We thank counsel for their submissions. We will retire to decide deliberate the matter, okay, the case. Thank you.
The Honorable Court is now adjourned. Judges, you are now invited to enter the judges' deliberation room to deliberate. Participants, you are required to enter the participants' holding room now. Thank you. Sorry, just to confirm before I begin, am I audible?
Yes.
Yes.
Judges, we'll just wait for the participants to join us as well. Yeah. Sorry, but Ms. Raja Aileen, I think your camera is turned off.
I think she said she's going off for a while to do her prayers. Yeah.
Hello, everyone. Welcome back. We'd like now to invite the judges to give their feedbacks. Thank you.
Before that, can everyone hear me? Right. Before that, I would like to invite Justice Ong to give counsel the views of the court in relation to the 4 questions that were posed. I think it's helpful to just give an idea as to how we look at the matter. Right. Justice Ong?
All right. First, thank you very much to both parties for what I think was an excellent presentation of your respective issues. The 4 issues that were put before us really not something that not something that is not commonly dealt with by the courts. Now, on the first issue of legal professional privilege, we are unanimous that really the issues is to be governed by Section 126 of the Legal Profession Act. And we are of the view that the documents are not discoverable under the section. we are not persuaded that we should follow the dominant purpose test that is found established by the UK courts. And in fact, we are going basically just on the wordings of Section 126, which we think are really quite broad, and we cover all communications between counsel and their client. Insofar as the second issue is concerned, as far as consent order, we are also unanimous that the counsel always has an implied authority on behalf of the client to enter into settlement negotiations and settlement terms on behalf of their client. And for that reason, we don't see any basis for setting aside the consent order. On the issue of frustration, we are not persuaded, although very forcefully argued by the second appellant's counsel, the appellant's second counsel rather, that we should make an exception to the rule in this case because of the extreme circumstances, but we do not think that it merits such an extension. And finally, on the issue of exemplary damages, again, we do not think that this is a situation which merits the courts to award exemplary damages. All right, but these are just the observations that we have. It's all unanimous. It does not reflect at all on the performance of the parties in so far as their argument is concerned. Thank you.
Now, just a few words from us. Now, we're given to understand that the speakers have been in your first and second year in the law school, and I think you all did very well indeed. But there are a couple of points I would like to make. Firstly, I think you should learn to speak a bit slower, because if you speak a bit too fast, you may tend to trip on yourself and get all tied up. Just take your pace, take it easy, so that you are less. You won't be flustered so easily. And secondly, you must also be flexible. You must look at things around the case and not just from the point of view of your line of argument, so that you'll be able and ready to address any issues that may come to you from a different perspective. So think around a problem, and often it is quite good to put yourself in the shoes of the other side and to see, look, what would they argue? What would their best arguments be? What would your answers be? So always try to be flexible, think around the problem, and be prepared to respond. Now, thirdly, when submitting, it's quite good to speak to the judges. Don't just read out, don't just throw your line of argument across. Try to engage the judges as though you are talking to them, talking to a friend and trying to persuade a friend that, look, I think this case should be decided on this basis rather than on the basis that the other side is suggesting. So try to engage the court rather than to just read out and submit. Yeah. So bear that in mind. The objective is to persuade. So speak to us. Yeah. And last but not least, I think the term used is my learned friend, not learned opposing counsel. That is well established. Okay. Apart from those general observations, again, I would like to reiterate that you each did very well. Now, I invite Justice Ong and then Raja Elaine Suraya to address you and their thoughts. Yeah.
Thank you. And again, I echo Justice Goon's view that the quality of your presentation is above average as far as I'm concerned, and that you should not try to speak too fast. Yeah, and when you speak too fast, it comes across as if you are reading. And not only that, we as judges will have some difficulty trying to understand your argument. Right? So the important thing is to make sure that your point comes across to us. And it is best done by, as stated by Justice Goon, you engaging us as if you are conversing with us. And you should also focus a lot on the facts of the case. I find that a lot of time counsel make a lot of submissions on the cases and then spend a bit of time focusing on the facts of those cases that you have cited, but without distinguishing those facts from the facts that are before the court and highlighting to the court what are the significance of the facts that you are now facing and how either it reinforces the decision of those cases which you want the court to follow, or to tell the court that, look, those cases can be distinguished on those facts. So the ability to master the facts really is, in my mind, one of the most important assets that you want to have as an advocate. And I am particularly pleased to see that some of you can respond very well to questions that was put to you. For example, if I may, I thought that Ms. Joy Tan, when you responded to questions put by us, by referring us to the COVID legislation, that was a good one. That was not something that I expected, and it made me thought about your argument, and it was not something that you had prepared, as you have said, but you have kept it right aside, so that when the question arose, you were able to respond and respond very effectively. And I was also very impressed with Ms. Po Kaman in your submission, because I thought that you had a very difficult point to argue. A very difficult point to argue insofar as frustration is concerned. And I had thought before you have started, how would you have argued this point? And you managed to push me to a point where I thought, maybe I can consider exploring further the argument that you have posed. And that to me is good enough. When you come to court and you are able to push the judge to a point where he starts to think about your argument seriously, then you have made your point, right? Rather than giving up too easily when you are confronted with a point that is put to you by the judges. Maintain it, try to push it, and let them see perhaps an angle which they have failed to see. And I think, Ms. Po, you have done very well in that. Yeah. All right. Yeah. That's all from my side. Thank you very much. And again, congratulations, all of you have done an excellent performance. Thank you.
So if I may be allowed to just say a few things as well. I can say, I think we were so impressed, and how difficult it is to impress this bench, I can tell you. This is not an easy bench to impress. I'm a mere mortal, I'm not a judge, unlike Justice Goon and Justice Thong, and I know the expectations of advocacy, if you appear before them, is very high, even for practicing advocates. So to impress them, you should really pat yourselves on the back. I do want to talk a bit about the questions, and I do apologize, we were very hard on you with questions. Questions were coming fast and furious, wasn't it? And the reason why we were asking questions actually were to enable us to draw out the better advocate, if I were to put it that way. Because I think in answering the questions, in responding to the questions, it was there, then we were able to then discern, because we have to decide, isn't it, who's the best oralist and so on and so forth. To help us make that decision, we had to ask the questions to see and assess the responses. And we could tell, I think, from the way the responses were coming out, who was the better advocate. And can I talk a bit about how to prepare for questions, even when we're in court? That is always something we dread. We're so scared that the judge will ask this question that I have absolutely no answer to. And there will always be that, it's always, frankly, that weakness, that elephant in the room, definitely they will ask. Definitely they will ask. You think they won't, they will ask. Okay? They would have read the file, they know exactly where your weak point is. You think you can, you cannot, they will know, they will ask. So prepare for those really, really tough questions. And if you give yourself time in the quiet of your room to think about, he's going to ask this question, she's going to ask this question, what is going to be my anticipated response? So you don't just prepare your main stuff, prepare your answers to the difficult, obvious questions. That would be my sort of hint or my tip. My second tip is, because I know I'm speaking to a large group of very young people, is when you are out there looking for a place to learn from, okay? Because now hopefully be finishing your degree, then hopefully moving on to chambering. So when you're looking for that spot to chamber with, spot to trade, look for the hardest taskmaster around. Look for that person who's going to question you, who's going to not sort of just let you get on without giving him or her the right answer or the answer that satisfies him or her. So that's what I did. Because my mentor is here. Justice Goon was my mentor. I worked with him for 20 years. So I was being asked those difficult questions that you guys sort of saw a bit today for 20 years. So if I can survive that 20 years in court, I can then keep my composure because I'm used to it. I'm used to it. So the thing about answering difficult questions is anticipate and then keeping your cool and really learning, I think, from people who are hard on you. But I mean, Justice Goon was hard, but he was fair and kind, and he was very generous with his teaching. That is the kind of mentor that you want when you go out there, if you do want to come into practice. And I wish all of you the best of luck.
I trust you're not appearing soon, Rajathi.
I'm sorry. Kill me. Kill me now.
Right. And, yes, bailiff.
All right, thank you, judges. We will now proceed with the photography session.
Everyone, please look into your cameras and smile. 1, 2, 3. And again, 1, 2, 3. Please give me a minute while I check the pictures. Great. Bailey, I'll pass the floor back to you.
Thank you. All right, thank you so much, everyone. We have now come to the end of the grand finals of the Taylor's Intervarsity Mooting Competition 2021. On behalf of the organizers, I would like to extend a word of gratitude to our sponsors, Raja, Darryl and Low Advocates and Solicitors, Srinivasan Young Advocates and Solicitors, Ernest Azad and Associates, and Taylor's Law School. For those of you who have joined us via the live stream, do stay tuned as we will commence the closing ceremony momentarily. Judges, you may now leave the meeting if you wish. Have a nice day. Thank you so much, everyone.
Thank you.
Thank you.
We are going to start preparing for the ceremony. So those who are staying on, you may switch off your cameras for a moment, and we'll prompt you when you need to turn your cameras back on. Thank you.
A very good evening to young Arif, Tuan Darryl Goon Siew Chye, Court of Appeal Judge, young Arif, Tuan Ong Chi Kwan, Judicial Commissioner of the High Court of Malaya, Ms. Raja Eileen Soraya, Dr. Harmahinder Singh, Head of School, Taylor's Law School, Mr. Hacharan Singh, Senior Lecturer and Moot Master of Taylor's Mooting Society, ladies and gentlemen. Welcome to the closing ceremony of the second Taylor's Intervarsity Mooting Competition. I'm Nisha, Vice Captain of Taylor's Mooting Society, and I will be your MC for this evening. Before we begin, we'd like to sincerely apologize for the delay. To all of our delight, the final round ended up going on for a little longer than expected, but we learned a lot and we certainly all enjoyed the show. Now, in order to begin the closing ceremony, we'd first like to acknowledge and thank our sponsors, Taylor's Law School, Raja Darryl and Low, Advocates and Solicitors, Srinivasan Young, and Ernest Azad and Associates. To kick off the closing ceremony, I would now like to invite Ms. Charmiane Fu, Captain of Taylor's Mooting Society, to say a few welcoming words. Charmiane has been a part of Taylor's Mooting Society since it was first founded by Amitesh Deva in January 2019. Luckily for us, she decided to stick around, and we are very, very grateful that she did, because this event would not have been as smooth sailing or as well thought out as it was without her here. Charmiane, over to you.
Good evening, Young Arif, Tuan, Darryl, Goon, Siew, Chye, Court of Appeal Judge. Young Arif, Tuan, Ong Chi Kwan, High Court Judge. High Court Judicial Commissioner of the High Court of Malaysia. Puan Raja Elaine Suraya, Dr. Harmahinder Singh, Mr. Hachan Singh, participants, volunteers, and everyone else who are here with us today. And thank you, Nimisha, for that sweet introduction. So we have finally come to the closing and awards ceremony. It has truly been a roller coaster ride for all of us here in the Taylor's Mooting Society board. And since we first started organizing the Intervarsity competitions, our aim has always been to provide a platform for budding mooters to experience mooting in a competitive setting before venturing into more advanced competitions. And at the same time, to serve as a bridge for law students all over Malaysia to meet, interact, and network in an effort to foster camaraderie as fellow future members of the Malaysian legal fraternity. Now, with the pandemic, we added a new layer to this experience by going virtual, thus allowing our participants to also have a head start on the new norm of online hearings. I truly believe that we have accomplished all of our aims and goals in these 2 days. The success of this competition is thanks to a long list of people whom I would like to thank and acknowledge on behalf of the Taylor's Mooting Society. First off, we would like to thank our dear Moot Master, Mr. Hachan, for his guidance and assistance throughout this journey. Next, we would like to thank our event sponsors for graciously sponsoring the attractive prizes that our award recipients will be receiving today. Taylor's Law School for the cash prizes and medals, Raja Darryl and Law, Surrebuttals Young, and Ernest Azad and Associates for the internship opportunities. We are also extremely grateful to the judges who have sacrificed their weekend with us to judge this moot competition. I am sure our mooters have benefited from your guidance and feedback. In addition, we could not have carried out the moot round smoothly without the help from our volunteers assisting us as bailiff, assistant bailiffs, and timekeepers. A big thank you goes to all the participants for your interest in this competition, and also our founder Amitesh for drafting the moot problem. Last but not least, I would like to thank my reliable and dedicated board of directors who have worked tirelessly in planning this since last September to what we accomplished this weekend. They are Nimisha, Adrian, Eng Hong, Jo Kao, Lian, and Yong En. Ralph Waldo Emerson once said, "Nothing great was ever achieved without enthusiasm." And the greatness we achieved this weekend is born out of the magnitude of enthusiasm we received from everyone. To give an overview, we had 51 judges in total, with 49 practicing lawyers from 37 law firms and 2 judges from the judiciary. We had 60 participants registering from 8 institutions and 43 volunteers from 9 different institutions. It is truly humbling for us to receive such massive and tremendous support from everyone. It is a competition, and as such, there will only be one winner. Nevertheless, I hope all of you take pride in taking this effort to start mooting. I, for one, am very proud of each and every one of you for the courage you have shown. I hope that you are able to appreciate the value of the experience you had here, and all the best. And I'll now pass the floor back to Nimisha. Thank you.
Thank you, Charmiane, for those very genuine words of thanks. Next, we'd like to invite one of the finest lawyers that our Moot Master, Mr. Hacharan, says he has ever had the privilege of knowing. They actually pupilled together back in the day, and he is now a Court of Appeal judge. Please welcome the presiding judge of the grand final rounds of Taylor's Intervarsity Mooting Competition 2021, Young Arif, Tuan, Darryl, Goon, Siew, Chye. I'm sorry, Young Arif, you're muted.
Right. Good afternoon, everyone, wherever you may be located. First, I would like to thank the organizers for the privilege of being invited to participate in this year's final leg of the Moot competition. I must add, I enjoyed it very much. From what we have witnessed this afternoon, and after conferring with my 2 colleagues, we are in agreement that the future of legal advocacy looks bright indeed. We are also comforted to observe that the concern for and training of advocacy is very much alive and well in our universities. The participants were prepared and performed well. They are each material for excellence at the bar should they choose to practice. On my part, I would say to those who would choose a career at the bar, or even a career where oral presentation or persuasion is called for, it is an art that can be developed, and all will come with commitment, persistence, and of course, as always, a bit of luck. For some time now, advocacy in our courts have entered a new phase. With the advent of this ghastly pandemic, we can expect more challenges, more changes on how we do things, including changes in how court proceedings are conducted. The pandemic has accelerated this change. A good example would be the rapid and recent amendments to the Courts of Judicature Act, introducing the use of remote RCT, remote communication technology, into our judicial process, and the slew of practice directions to facilitate its use. As a consequence, our courts have been able to sit virtually and regularly, not long after the imposition of the movement control orders. The pandemic's impact on access to justice was thus minimized. This adaptation has heralded an even greater dependence on technology and the emergence of what has been described as a partnership between the law and technology. Technology itself has brought challenges to the law. Industries now have new ways of doing things and new products such as blockchain ledgers, smart contracts, and cryptocurrencies. The law too will have to adapt and evolve in the way it does things. The jurisprudence of our judicial process will have to evolve, as is evident when I compare how things are done today with how they were done when I started practice at the bar together with Mr. Hacharan Singh. I recall fondly those days when advocates had to bring volumes of law reports and textbooks in wicker baskets to court. We didn't use photocopying machines. They were not generally available. Pleadings and opinions were drafted in longhand, and there were many who were employed merely as typists, and they did nothing else. To be found in everyone's desks were an eraser and a ruler. And the first mobile phone, when introduced, was the size of a furniture. These are rarely, if ever, encountered today. Even the judge's handwritten notebook is now replaced with laptops, and yes, computer notebooks. In addition, some judges even use multiple monitors plus iPads to access documents when on the bench. What was an evolutionary change has been expedited by the pandemic. Almost overnight, we had to adapt to virtual hearings. Before then, many of us had not even heard of Zoom. More than ever, oral advocacy has now to share its role with another form of persuasion, and that is, of course, written advocacy, both delivered with the aid of technology. Oral persuasion in our courts has been impacted such that while there remain opportunities for it, not much time is afforded to it. As far as oral advocacy is concerned, it is irrefragable that written advocacy, coupled with the paucity of time, has curtailed the opportunity for lengthy oral arguments. The style of oratory and eloquence of a Cicero of Rome, for example, would not have flourished in today's legal environment. Because all that has to be said is produced in written submissions, and if I may add, very often much more than is necessary, coupled with the pressure of ever-growing judicial work and the non-elasticity of time, oral advocacy is almost merely an addendum to written advocacy. Because written submissions are filed, served, and read in advance before the hearing, greater pressure is now therefore placed upon the advocate at the oral submission stage. Greater cerebral effort, if you like, is demanded of the advocate to produce effective, incisive oral arguments in the relatively short time that is allowed when what needs to be said has already been said in writing. The advocate has therefore to think very carefully what he wishes to say, what points to address and highlight, in what order and how to do it. Belaboring the obvious or simply reading from written submissions will provoke short shrift from the bench. Careful preparation and much thought are therefore required. However, employed thoughtfully and aided by written form, oral advocacy can be even more powerful a tool than it ever was. Some succeed, some do not. I would suggest that those who do not have not invested sufficient thought about the process. Compact and incisive oral advocacy is an art form. It can be learned. It can be developed and honed with practice. It requires a combination of skill and effort, a clear understanding of legal principles, mastery of the facts, and an understanding of what would be persuasive and what it takes to persuade. It is this changing trend that I would, if I may, be so bold to suggest that equal emphasis at least be given to written advocacy as is afforded to oral advocacy by law faculties of our universities. And perhaps more moot competitions too may be devised to accommodate both these forms of persuasion. With that, I thank you and wish you all a very pleasant evening.
Thank you, young Arif, for that very insightful and meaningful speech. Next, we'd like to call upon the head of school of Taylor's Law School, Dr. Harmahinder Singh. Dr. Harmahinder Singh has offered a great deal of support towards all the initiatives taken by Taylor's Mooting Society over this past year that has been filled with uncertainties, be it new online mooting competitions or sponsoring very lucrative monetary prizes for competitions such as this one. Dr. Harmahinder, alongside Taylor's Law School, has been the support system of Taylor's Mooting Society over the past few years. Over to you, Dr. Harmahinder.
Thank you very much, Charmiane. Young Arif, Justice Darryl Goon. Young Arif, Justice Ong Chee Kwan. Yang Mulia Puan Aileen Raja Aileen Soraya. Mr. Harcharan, our very able moot master. And academics who are in the room, in the call, students and participants. Firstly, I must thank our judges who presided over the moot competition, the finals this afternoon, sacrificing perhaps your entire weekend on a Sunday, afternoon on a Sunday, to spend time with our students, sharing your thoughts and helping them improve. I must record my heartfelt gratitude and appreciation for this, for your invaluable time spent with them. And we hope that you would continue to support us in the many moot competitions to come in future. I must also record our heartfelt appreciation for our sponsors, Srinivasan Young, Ernest Azad and Associates, as well as Raja Darryl and Goon Raja Darryl and Loong for your support for this moot competition. Secondly, it is in order for me to thank and recognize Mr. Harcharan Singh as our moot master. Mr. H, as he's now fondly known, spends hours with our students to train them and to prepare them for such competitions. And I think I always tell Mr. Harcharan that it's not about winning, but it's about the experience and the learning that the students acquire with their engagement with him that is most important. Thirdly, I must thank Charmiane, Nimesha, and the Mooting Society team for executing this event almost flawlessly. I was watching on YouTube, and I thought that the quality of the participants were definitely up to par. And definitely there's so much more that they can learn and improve upon. I'm very proud that the Moot Society has come so far in such a short period of time. Thanks to our founding alumni, Mr. Amitesh Deva, who set the foundations for this society, and Charmiane, who was at that time, I think, his vice captain, who's now taken over as captain. Congratulations to all of you in the Moot Society for doing a fantastic job and to keeping up with the tradition of Taylor's Law School. I must invite you to continue with this Intervarsity Moot competition even in years to come, as it provides a platform for students to learn from one another, and most importantly, to learn from the learned judges and from their peers. So I congratulate all of you. I thank our judges once again, Mr. Hacharan, also for your kind support for this entire event. I thank all of you for what you have done. Thank you and have a wonderful evening.
Thank you very much, Dr. Harmahinder, and thank you for taking time out to come and speak at our closing ceremony. Finally, to wrap up all the speeches, we save the best one for the end. I'm kidding, we don't actually. I don't think I'm allowed to say that. Someone who has given up countless weekends and weeknights to Taylor's Mooting Society. Any person in Taylor's Mooting Society will call this man the heart and soul of Taylor's Mooting Society, our Moot Master, Mr. Hacharan Singh.
Okay, thank you, Nimesha. The Honorable Mr. Justice Darryl Goon Siew Chye, the Honorable Mr. Justice Ong Chi Kwan, Ms. Raja Eileen Suraya, Dr. Harmahinder Singh, ladies and gentlemen. You know, every day I learn something new. Today I was reminded of a very old lesson, and that is never try and wing it in a speech. When I was asked to say a few words, I didn't expect such erudition and structured speeches from the speakers before me. It's my fault, really. I should have known that Mr. Justice Darryl Goon always comes up with the best of speeches, and so does Dr. Harmahinder Singh, but I keep forgetting this, So just as recently as about an hour ago, when I was talking to my Mooting Society, they said, "What are you going to talk about, sir?" I said, "Well, don't worry, I'll just wing it." And here I am winging it, so I'm sorry if I ramble on a bit more. Now, the other problem is also this, what I thought I would say, what I could wing it with. The material has been taken all away from me already. By Charmiane, thanks to you, Charmiane. By Nimesha, thanks to you, Nimesha. Well, I can't use the same tone on Dr. Harmahinder. He's also taken a lot out of my speech. So I will, forgive me if I repeat a few things here. And my intention, so I'm going to go ahead with whatever I wanted to say anyway. Now in 2016, I was asked to be the Moot Master. Mooting was not particularly popular in Taylor's Law School. We had a law competition called the Law Asia Competition 2016 coming up. Very ambitiously, I called for selections, trials, so to speak. The response was overwhelming. 6 students came for the selection. And being the good judge I am of character, I selected all 6 of them. We formed 2 teams. And that's how my journey with mooting in Taylor's Law School began. Now these students were selected. One of the teams did very well. We finished runners-up in the national rounds of the Law Asia. They went on to the international rounds in Sri Lanka and were placed third overall. Now, I like to think that that was the seed of the growing interest in mooting in Taylor's Law School, and that I was instrumental regarding it somehow. But that's not true, because the watershed event of the development of mooting in Taylor's Law School is actually the founding of the Taylor's Mooting Society. It was a brainchild of two, how would I say, very adventurous students. Amitesh Devanandan was then the president of the Law Society, and his venerable, he likes to call him his sidekick, but actually he's a lot more than that. The vice president, then vice president, Lucas Isaac. It was these two gentlemen who came up to me one day in the holidays of December 2018 and said that we would like to start a mooting society. My first reaction was, yes, go ahead, but please don't involve me too much. I'm already too busy. But then, you know, I never lived up to that threat. So anyway, from that moment onwards, actually, mooting has taken a hold amongst the Taylor's Law students. Okay, it was the vision of those two young men that we are actually seeing today. Of course, their vision would not have been fulfilled or even come to the stage that it has reached were it not for the untiring efforts of the mooting committees that followed after that. So the first mooting committee co-captains Tiffany Chin and Iqbal, I would like to record my appreciation and thanks for what you've done. And also your committee members. Now, I'm sorry I don't have the piece of paper that I should have had to mention the names of the committee members. And I do apologize to them. There you see, again, winging it has got its problems. Huh? So mooters, please, whether you're from Taylor School or whether you're not from Taylor School, take that into account. This is not something you should be doing. All right. Then, of course, their stellar work was followed by the current mooting society of year 2020-2021, ably led by Charmiane, the captain. Sorry, her name is Charmiane, she tells me. I apologize to you, Charmiane. You need to spell it correctly, Charmiane. And ably assisted by Nimesha Devanandan, who incidentally is a sister of our founder, Amitesh Devanandan, who incidentally is also the draftsman of this particular moot problem that we have all been grappling with over the weekend. Okay. In addition to that, we have the current member of the Secretariat. Thank goodness I can see their name, so I will. Secretary Adrian Cho, well done. Treasurer Ong Eng Hong, who I always say the man with the gold, who makes the golden rules. He decides what we can do. Lien Yap, New Jo Kyle, and Yungen. All right, thank you so much for all of you. So I'm here today actually to acknowledge the hard work that you've put in. If the mooting society, if the mooting culture in Taylor's amounts to anything, it is entirely due to the efforts that the mooting society has put in thus far. And of course, the mooters who have responded to it very well. Now, I've gone on a bit about Taylor's. It would be remiss of me if I do not include all the participants from the other universities who participated in this. I must thank all of you for accepting our invitation and for putting up a really good performance, I'm sure, all through. Okay. Additionally, thanks are due to all the judges and volunteers, the sponsors, and if there's anyone I've forgotten to thank, then I'm sorry. Yeah? Okay, I think with that we've come. I would like to stop because you all are waiting very excitedly to find out who won and who are the best 10 speakers, so on and so forth. Thank you very much for your indulgence, and I apologize for rambling on for so long.
Thank you, Mr. Hacharan. As always, it's a pleasure and a privilege to get to hear you ramble on. Thank you to all the speakers for your great speeches. We will now move on to the part of the ceremony that everybody has been eagerly waiting for, the award ceremony. Before we begin, I'm just going to walk you through how exactly we will conduct the online ceremony, given that I'm sure not many of us have been through one before. So we'd like to request for everyone present here, with the exception of Young Arif, Tuan Darryl Goon Siew Chye, Young Arif, Tuan Ong Chi Kwan, Ms. Raja Eileen Soraya, Mr. Gopal Srinivasan, Dr. Harmahinder, and Mr. Hacharan to please turn off their cameras. When we announce the award winner, the respective award winner, would you kindly turn your camera on? And for everyone to sort of be able to see who exactly the award winner is, and also so that we may take a picture with all the award winners. I'm sorry, Young Arif, I said with the exception of the Young Arif. So Young Arif, Tuan Darryl Goon Siew Chye, and Young Arif Ong Chi Kwan. Thank you for turning your cameras back on. Okay, great. So I'm going to share my screen and we will begin the award ceremony immediately. Okay, great. So welcome everyone to the award ceremony of the Taylor's Intervarsity Mooting Competition 2021. So, sorry, some technical difficulties. First off, we'd like to start by announcing our top 10 best oralists. So these are the speakers who ranked highest in terms of speaker scores over the 3 general rounds that we held yesterday. So first off, in 10th place with a speaker score of 255, Chong Le Yi from team 1018. So Mr. Chong Le Yi, if you could please turn on your camera. Oh, Miss Chong Le Yi. Leanne will now take a picture for everyone.
Okay. I'm actually from team 1004, just for information.
Oh, we're very sorry for that error. We will correct it immediately.
All right. Smile, everyone. Okay. 3, 2, 1. Sorry, Aklima, could you please turn off your camera? All right, one more. 3, 2, 1. Okay, thank you.
Thank you. Next, also in 10th place, so we had quite a few ties within the top 10 ranking. So in 10th place, alongside Chong Le Yi, is Rafiq Rais from team 1018, I presume. We must have mixed up the team numbers. I'm very sorry. So Rafiq Rais in 10th place. Would you please turn on your camera for a photography session?
Okay. 3, 2, 1. One more. 3, 2, 1. Okay.
Okay. Thank you very much, everyone. I'll have to apologize. I think we underestimated how long it would take us to get through individual pictures with every single one of the top 10 best oralists. So what we'll now do is I will announce all the top 10 best oralists and we will come together for a group picture after this. I'm very sorry, and moving on. In 9th place with a speaker score of 256, we have Ng Hua Jian from team 1020 and Lee Garfa from team 1022. In 8th place, with a speaker score of 257, we have Yong Hao Jet from team 1006. In 7th place, with a speaker score of 258, we have Ng Chun Kiat from team 1024. And in 6th place, with a speaker score of 259, we have Isaac Bani Anak Colin from team 1021. In 5th place, with a speaker score of 262, we have Tan Ka Loong Keanu from team 1017. In 4th place, with a speaker score of 267, we have Amin Firdaus bin Azizan from team 1010. In 3rd place, with a speaker score of 269, we have Tan Ying Yi from team 1001. And it so happens that the 3rd best oralist is also a tie. So alongside Tan Ying Yi, we have Bhuvanesh from team 1007. In 2nd place, with a speaker score of 270 points, we have Aklima binti Azizi from team 1010. And finally, the best oralist for the Taylor's Intervarsity Mooting Competition 2021, who will win a 100 ringgit cash prize, generously sponsored by Taylor's University, as well as an internship with Ernest Azad and Associates. With a speaker score of 278, Ms. Joey Tan Chuan Singh from Team 1017. We would now like to invite all the top 10 oralists to turn on their camera and please take a picture with our guest of honor. Including the ones who already had their picture taken, I'm very sorry. Chong Lei and Rafiq, I believe.
We're missing one more person.
Okay, I think Bhuvanesh is here now.
Oh, all right. Okay, smile everyone. 3, 2, 1. Hold on. Okay, one more. 3, 2, 1. Thank you.
Thank you, everyone, and congratulations once again to all the top 10 best oralists. For a competition that had about 60 participants, you all did extremely well and should be very, very proud of yourselves. Moving on now to the champion of Taylor's Intervarsity Mooting Competition 2021. Moving on first to the best oralist for the grand final round, Ms. Joey Tan Chuan Singh from Team 1017. Joey, would you like to turn on your camera and take a quick picture with the judges before we move on to the announcement of the champion?
Okay.
And this can double as Joey's picture for her best oralist for general rounds as well, since she won both.
Okay, 3, 2, 1. One more. 3, 2, 1. Yep.
Thank you, Leanne. Thank you, Joey. And now, finally, moving on to the moment that everybody has been waiting for, the champion of Taylor's Intervarsity Mooting Competition 2021, winning a 500 ringgit cash prize from Taylor's University, as well as 2 internship positions sponsored by Raja, Darryl, and Loong. We'd like to present to you Team 1017 from Taylor's University, Keanu Tan Kalung and Joey Tan Chuan Singh. Joey and Keanu, if you would please turn on your cameras and take a picture with the guest of honor. Congratulations once again on being champion.
All right. 3, 2, 1. One more. 3, 2, 1. Okay.
Thank you. I hope everyone enjoys the clapping sound effects we added in because during our last award ceremony, we tried getting everyone to clap in real time and it was very underwhelming and anticlimactic. So congratulations, Joey Tan and Keanu Tan, not related, purely a coincidence. That means now that the runner-ups of TIVC 2021, winning a 250 ringgit cash prize sponsored by Taylor's University, as well as 2 internship positions with Srinivasan Yang, Team 1028 from Taylor's University, Lau Ruitong and Po Kaman. Kaman and Ruitong, if you would please turn on your cameras and take a picture with everyone here.
All right. 3, 2, 1. One more. 3, 2, 1.
Okay, thank you very much, everyone. That brings us to the end of the closing ceremony for Taylor's Intervarsity Mooting Competition 2021. Thank you, everyone, for being here today. Thank you to all our sponsors, as well as the judges, lecturers, mooters, and volunteers. We really do appreciate you taking your weekend to spend with us, and we hope you had a wonderful time, because we certainly did. It has been a roller coaster of a ride, and we really enjoyed hosting Taylor's Intervarsity Mooting Competition 2021. Judges and lecturers, you may now leave if you wish to do so. If you want to stay on, you can. We'll be taking a group picture with all the participants here today. So if everyone could be requested to turn on their camera. Thank you. To everyone who did not win, you did a wonderful job regardless. We heard such lovely things from you from all the judges involved. So congratulations, you should all be very proud of yourselves. Okay, I think Dr. Harmahinder, Mr. Hacharan, Ms. Raja Eileen, as well as young Arif, Tuan, Darryl, Goon is staying. So yeah, they'll be in our group picture. Everyone smile.
Okay, 3, 2, 1. One more, 3, 2, 1. Okay, got it.
That officially brings us to the end of our event. Thank you everyone for coming and have a great day ahead, or a great evening ahead.